All rise. Court is back in session. Please be seated.
Okay, we're ready for our second case, MESA Underwriters Specialty Insurance v. Henson Novelties, Inc. If you're ready, we'll hear from the appellant.
May it please the court, my name is Edward Suslik from the law firm of Callahan & Blaine, located in Irvine, California. I've been admitted pro hoc vice with respect to this case and with respect to this appeal, as well as the defense of the underlying action, for which we are lead defense counsel. I represent defendant Henson Novelties with respect to this action brought by its insurer MESA, and I would like to reserve 10 minutes for rebuttal.
Okay.
I think both parties, your honors, agree that the standard of review in this matter is de novo. It is our position that the court came to the wrong conclusion in the underlying action. And specifically, it is our position that the court made a number of errors on both procedural issues that are outside of the substantive coverage arguments, as well as the substantive coverage arguments, but that specifically the procedural issues then led to the erroneous findings on coverage.
Before you get too far into that, I caught this in review. There is or was a second defendant in this declaratory judgment action, and the judgment in the pleadings did not relate to that other defendant. Is that right?
That is, well, they've been settled out. That's the landlord.
Okay. Is that actually reflected anywhere in the record before us? I see that said in the statement of review, but there wasn't a record citation, and I did not see anything in the record that reflected a voluntary dismissal or anything else that would resolve the case against that other defendant. And so it just raises concerns that this might be an interlocutory appeal.
Very good, Your Honor. Well, I'll consult with counsel. I mean, they're the plaintiffs, so they're the ones who settled with the landlord. I'm sorry. The underlying plaintiff settled with the landlord. Presumably, they also reached a resolution on this coverage action, but you're correct. There's nothing in the record. So as I was saying, Your Honor, a procedure does determine substance many times, not just in insurance coverage law, but also law in general. First and foremost, Your Honor, as we point out, we believe that the trial court applied the wrong standard on the duty to defend. I just cannot be reasonably disputed that the trial court looked only at the four corners of the complaint and did not apply the standard set forth in the Kubik case and the waste management case, which is the law in North Carolina. In waste management, the North Carolina Supreme Court held that where the insurer knows or could reasonably ascertain facts that, if proven, would be covered by its policy, the duty to defend is not dismissed because the facts alleged in a third-party complaint appear to be outside coverage or within a policy exception. This is known, Your Honors, as the eight corners rule. So you look at the four corners of the complaint, but you also look at all the other facts that are extrinsic. Not every state has this test. North Carolina does, and the trial court applied the wrong test.
How does that interplay with the procedural posture of this case? Because this was judgment on the pleadings.
Correct.
In this case, so that's sort of overlaid onto the review of the underlying pleadings and other facts, I guess.
And you're going exactly to my next 2 points. So you read my mind, Your Honor. Very good.
Well, I don't know about that, but we'll see.
I'm just saying, it's in my outline. I'm getting to that point. But when you apply the wrong standard on the duty to defend, it's going to lead to the reversible errors that occurred on the motion for judgment on the pleading. So as a direct corollary of the court's failure to apply the correct standard on the duty to defend, the court also wrongfully denied our motion to stay. It is black letter case law in North Carolina, as it is around the country, that when a carrier sues its insured for coverage, there is a strong presumption for a stay because of the prejudice to the insured that results from, among other things, discovery that is going to be conducted in the coverage action, which could then prejudice the results in the underlying action. So because the court found that he was not going to consider extrinsic evidence, he denied the motion to stay basically as moot because there is no discovery to be conducted. And such discovery is actually critical to the process of the finding of a duty to defend in this case because the defense obligation is so broad. As it turns out, the underlying action, now it's 2 years later basically, the underlying action is proceeding to trial. So if this court were to reverse the judge's ruling on the motion for judgment on the pleadings, the motion to stay would not necessarily be relevant at that point. There will be facts, and this is part of my exposition, that a adjudication of coverage requires, especially on the duty to defend, requires actual facts, actual admissible evidence, and much of that evidence is gathered from discovery in the underlying case. 2 years ago, that discovery was nascent. Now the discovery and the trial will be coming up later this year, and those facts can then be applied to this coverage case. With respect to the motion for judgment on the pleadings, the primary reason that the court rejected our right to discovery is because the trial court wrongly relied on a complaint in the underlying action to determine the facts in the coverage action. And I have, in my 36 years, had not seen this situation before, where a carrier agrees to defend, so there is at least a presumption that there is a potential for coverage and the duty to defend is triggered, and then they file a deck relief action, attach the underlying complaint to the deck relief action, and then ask the trial court to take essentially judicial notice of every allegation in the complaint in the underlying case as true. And that turns the motion for judgment on the pleadings process on its head. While when a underlying complaint is used to demonstrate that there is potential for coverage, that's one thing. But you cannot use the allegations and admit them as true to try to prove that there is no potential for coverage, because there is many other bases for coverage and the potential for coverage on a duty to defend analysis that are outside of the allegations of the plaintiff's complaint. For example, the judge used the contention of the plaintiffs in the underlying action that the conduct of Henson was unlawful as one of the justifications for denying coverage in this case. We strenuously disagreed that our sale was unlawful. In fact, if you were to ask Amazon and Walmart and all of the other entities that sell this product, these cream chargers, they would likewise strenuously disagree that it's unlawful. Yet because the plaintiffs in the underlying action alleged that it was true, the trial judge used that allegation to conclude that there is no potential for coverage because, as Music argued, unlawful acts are excluded from coverage, and therefore there can be no duty to defend. So that is, I believe, I'm trying to address your question, Your Honor. When you have a motion for judgment on the pleadings, it is an inappropriate vehicle to adjudicate the duty to defend in this process. I've handled hundreds and hundreds of coverage actions. The appropriate process in courts across the country is to have either a trial of the facts in the underlying action. You can do it right there in the courtroom in the deck relief action, or at a minimum to have a motion for summary judgment after sufficient discovery has been conducted so that the court can look at actual admissible facts. As I pointed out to the trial judge in oral argument, there is not a single admissible fact before that court. There was no testimony, no declarations, there was no admissions. The only thing that the court had in coming to a finding that there was no potential for coverage, and again, an extremely broad standard in North Carolina law, is the allegations of the complaint, which we strenuously disagree with on every level. And that is reversible error, Your Honor.
Is there a place for judgment on the pleadings here, just as a procedural mechanism? You know, obviously you've got the declaratory judgment complaint, you've got responsive pleading, and then you can refer to any documents that are referenced or attached to the complaint. As long, you know, we're not trying to resolve issues of fact, we're just sort of taking these pleadings at face value. Is there a place there for a trial judge to look at this and just simply say, based on the pleadings before me, there's simply no set of facts under which coverage can be provided?
Well, Your Honor, absolutely not, because again, that would be a four-corner state. North Carolina, pursuant to the edict of the Supreme Court in the waste management case, mandates that a trial court look outside of the complaint for extrinsic facts, deposition testimony, evidence that the insured provides. I frequently provide evidence to the insurance carriers to trigger a duty to defend for potential for coverage. In fact, I consider that my obligation. But no, there is no situation that I can envision that I've ever experienced where an insurance company can file the complaint from the underlying action and then ask the court to deem all of those facts to be basically admissions against interest. They're not against our interest. We deny them. And there is no place for a judgment on the pleadings process.
And at this stage of the process on the pleadings, is there anything you can point to that would provide that kind of extrinsic evidence that would trigger the duty to defend?
Well, yes, I mean, absolutely. But again, we never had that opportunity given to us. The determination that the court made, we asked the court for discovery. We certainly believe, I mean, once I get to the substance, and I know I only have 19 minutes left, we certainly believe that the complaint in the underlying action triggers the potential for coverage under the insuring clause. Okay, there is an endorsement to the policy which provides that, and this is a very, very important provision in the policy, because we have all over the country, especially in California, we have policies that use the language "and." Here, the language that's used is "for" under the designated premises endorsement. And I'm going to read it to your honors. It's very short. And it says, "This insurance applies to bodily injury and property damage caused by an occurrence that takes place in the coverage territory only if the bodily injury or property damage either A, occurs on the premises shown in the schedule, or the grounds and structures appurtenant to those premises, or B, arises out of the project or operation shown in the schedule." So we certainly believe that ultimately, once the facts are developed in discovery in this coverage action, because we are entitled, your honors, to conduct discovery of the claim handler, of the underwriter. The claim file is the most important aspect of any insurance coverage case, but as is the underwriting file. Likewise, we are entitled in certain circumstances, and would certainly warrant that this is one of those because the exclusion at issue is ambiguous, entitled to see how the plaintiff, in this case the insurance company, applies that exclusion in other situations in what's called similar claims discovery. And it's a very narrow discovery, but a very important, and it looks just to the coverage determination. How has this exclusion been applied in 5 or 10 other cases by the insurance company? And we were never given that opportunity. But clearly, the insuring clause, from our perspective, has been met because the allegations and the underlying complaint arise out of the operations shown in the schedule. In fact, that is the whole gravamen of the plaintiff's complaint, that my client, the defendant Henson, sold these cream chargers, these cream cartridges, to these men who then used the cream cartridges in the parking lot, which also triggers A, by the way, that it occurs on the premises shown in the schedule, or grounds and structures appurtenant to those premises, which is a parking lot, and that the product then impaired them, so that there was an occurrence that occurred there as a result of our actions. So we believe strongly that the coverage, the insuring clause has been triggered. So then you move into the exclusion, and as we explain in our brief, first and foremost, exclusions are construed very narrowly under North Carolina law. They are construed against the drafter for public policy reasons. The carrier has the control control the policy. They can draft the language however they wish. Second off, there is a clear ambiguity, as we point out, in the policy between the coverage grant in the designated premises endorsement, what I just read to the court, which provides coverage for occurrences and injuries arising out of the operations, arising out of. And that's, again, a very important term in insurance law, because arising out of is very broad and very ambiguous, as opposed to use of some carriers use in their policies words like directly related or similar words. So these young men use the cartridges on our premises, and then it altered their body, altered their minds, and the accident occurred. So when the carrier, with one hand, Your Honors, provides coverage under the designated premises endorsement for acts and occurrences arising out of our operations, and then on the other hand, purports to exclude such conduct, it creates an ambiguity. And again, ambiguities are construed against the drafter. This is the Otto Owens case that we stated. B, MESA has a very heavy burden to prove that its exclusions apply, which it did not meet here because there's no evidence. So how can MESA meet its burden of proof when it has no proof? There's a complete failure. And again, from our perspective, that is a reversible error by the court, that he did not allow us to conduct the discovery, the depositions, and the other facts that we need on the insurance side, as well as having no evidence on the underlying action side. The judge has no idea what happened in that underlying action. He's relying on allegations in a complaint, which we strenuously oppose. So I tried to answer your question in that respect, Your Honor. As far as a further procedural error that occurred, I'm sorry.
Well, I also want to make sure you have the time to address sort of the facts of the case and how you contend duty to defend applies and the insurance policy applies to the actual facts of this case, how that fits in.
Well, so again, the duty to defend is extremely broad. So are there any facts that exist in the underlying case based on the extrinsic evidence which would trigger the duty to defend? And the absolute answer is yes. There are many facts in the underlying case that trigger the duty to defend. First and foremost, as I just explained, it is certainly our contention that we are within the insuring clause. There is a designated premises endorsement that covers bad acts, alleged bad acts by the insured arising out of, which causes damages arising out of such bad acts. From our perspective, coverage is absolutely triggered. The only next step and the only last step is to see whether or not that exclusion applies. We do not believe that that exclusion applies because of the substantive coverage interpretation rules, which is there's an ambiguity. The exclusions are construed narrowly against the insurer in North Carolina. There's a heavy burden of proof, and that requires actual evidence and proof, not just allegations in an underlying case. So we certainly believe that both on procedural and substantive grounds, the trial court should be reversed. We should be allowed to go back. Again, we are taking the position so that we don't have to address the issue of the stay, because the stay goes directly into my position, which is that before there can be any coverage adjudication, we should be entitled to conduct discovery. So we will withdraw our request for a stay. And we'll go straight to discovery. We'll adjudicate, we'll conduct such discovery. Facts will be developed, which will determine whether there is a potential for coverage. And then, like every other coverage case, there will be a motion for summary judgment on the duty to defend. At that time, the court can weigh actual admissible evidence. I don't mean to weigh. We'll determine whether or not the evidence is admissible, whether it's undisputed. If the summary judgment is not appropriate, the court will set a trial, and there will be a trial on that issue. The carrier is fully protected. They issued a reservation of rights. If they ultimately win, I believe they can get reimbursement of what they paid out. But what cannot happen is what happened here, where the judge simply says, oh, there's no coverage, even though I'm not going to ignore all the facts that could be developed. And one additional point I was going to make, this is just a procedural argument. There was a contention made in the appellate briefs by the appellee about alleged unlawful sale, but that argument was never made in the underlying action, so we believe that it's waived. You can't bring up new arguments. On top of that, the sale is not unlawful. That is a contention by the plaintiff, but in fact, these cream chargers are sold on Amazon and Walmart and many other places. So with that, I will cede to my distinguished opposing counsel. Thank you.
Thank you. We'll hear from the appellee.
Thank you, Your Honors, and may it please the Court. My name is John Soretta of Day Pitney for the appellee MESA Underwriters Specialty Insurance Company. I am admitted pro hoc vice in this matter as well, and I'm here joined at counsel table by Jim Bryan, my sponsoring counsel, and I appreciate the opportunity to appear before you today. We do ask the court to affirm the judgment on either or both of two independent grounds. First, because the policy's designated premises endorsement bars coverage for bodily injury, as alleged in the underlying complaint, which did not occur on Henson's premises or arise out of designated operations or projects. And second, the policy's products completed operations hazard, or PCOH exclusion, independently bars coverage because the bodily injury, again, as alleged in the underlying complaint against Henson, occurred away from Henson's premises and arose out of Henson's products or work. I look forward to answering the court's questions on both of those issues, but I would like to start with what I think is the most straightforward and easiest of the questions, and the only question that the court has to reach if it agrees with us on, and that is on the PCOH exclusion, which I think is quite clear on as a matter of the pleadings and the underlying complaint attached to the pleadings. I do want to, before I get into the substance though, because Your Honor asked about it, I do think there is a final judgment here. So the way this worked is that if you look at our motion for judgment on the pleadings, we asked for judgment on the pleadings as to both, and I think it's NC 3116 or something like that, and Henson. The court granted judgment on the pleadings as to both parties, and that's a 311, I think, of the record. And then NC 3116 did not appeal. So I think the only appellant you have before you is Henson, and that's the only issue you have. But I do think you have a final judgment that's been appealed from by Henson.
Thank you.
Now, on the PCOH exclusion, this court applies, under its case law, a comparison test. And this comes straight from Harleysville Mutual Insurance, a 2010 North Carolina Supreme Court case. To answer the question, the court said, we apply the comparison test, reading the policies side by side with the complaint. And that includes the underlying complaint attached to the pleadings. Now, I do want to address, before I get into the substance, that procedural issue that my colleague on the other side raised. Basically, that judgment on the pleadings, it's a no-go zone for this type of analysis. I don't think that's right. I think that's incorrect. And I'd like to give a couple of examples where this court, applying the North Carolina Supreme Court standards, has affirmed grants of judgment on the pleadings in this situation, where you have a policy where the language is undisputed. Everyone agrees it's an authentic version of the policy. And then you have pleadings and the underlying pleadings in the action that, yes, there are definitely factual disputes, of course, as to whether the plaintiffs in that underlying action are going to be able to prove their case. But the comparison test just looks at the allegations in the pleadings to see whether there is coverage in order to determine a duty to defend. So a recent example of this court affirming a judgment on the pleadings when faced with a similar issue, and we cite it a number of times in our brief, North Carolina Farm Bureau Insurance Company versus Hague. That's 283 NC App 215. Some members of the panel may recall that case because they were also on that panel. But that was a case, judgment on the pleadings, because the underlying action brought against the insured involved the discharge of a weapon. And the person was sued because, for wrongful death, because the discharge of the weapon resulted in the death of the underlying plaintiff. There was a coverage action that was brought. Judgment on the pleadings was granted because, and the court did this analysis, take the policy language, which had an intentional act exclusion, compare it to the allegations in the pleadings, which showed a discharge of a weapon a number of times that resulted in someone's death, and the court affirmed the grant of judgment on the pleadings. So this is a procedurally appropriate vehicle to do that comparison test. It happens under North Carolina appellate case law. Another good recent example, Ortez, I think we cite this in our brief as well, Ortez versus Penn National Insurance Company, 297 NC App 114. That's a 2024 case. Again, a judgment on the pleadings case. This time, judgment on the pleadings granted for the insured, but then goes up on appeal, reversed judgment directed because a fellow employee exclusion, policy language undisputed, compare it to the pleadings, that fellow employee exclusion did not provide coverage, no duty to defend. So I think we're procedurally proper here.
And that's true, I think, if the pleadings reflect there's no question of fact, right? Whether the shooting was intentional, whether this was a fellow employee tort. And maybe jumping around here a little bit, but you know, since your colleague raised it, it raises the question, is there a question of fact as to whether the actual sale of this product was in and of itself unlawful? Is there a question of fact there and is it that material, I guess, or the
Yeah,
question?
so I don't think so, because if you take the allegation as alleged in the underlying pleading, I think it's at paragraph 91 of the underlying pleading, that the cashier, and then it parrots the language of the state's Toxic Vapors Act. It says, let me just make sure I accurately quote it. The cashier sold the chargers with reasonable cause to suspect they would use the products for the purpose of intoxication. That's just parroting the language of 9113.12 of the state's general statutes. And so it's alleging an unlawful sale. And so we think that, yes, that is sufficient that's the allegation of the complaint, alleges an unlawful and indeed criminal sale, and so it is not within the designated premises endorsement. But if Your Honor has any concerns about that, and that's what I wanted to do, was start with the PCOH exclusion, because I think there we have an extremely straightforward application of the comparison test to go through, and that provides ample grounds for affirming the judgment. So if I could start there. The comparison test. Okay, start with the policy language. The PCOH exclusion is on page 92 of the record, and it says, this insurance does not apply to bodily injury or property damage included within the product's completed operations hazard. Okay, product's completed operations hazard is defined in relevant part at page 79 of the record to include, quote, all bodily injury and property damage occurring away from premises you own or rent and arising out of your product or your work. So from our perspective, take that policy language and also the language in the insuring agreement, which is at page 65 of the record, and says very clearly, we will have no duty to defend the insured against any suit seeking damages for bodily injury or property damage to which this insurance does not apply. So what are the injuries for which damages are sought in the underlying complaint. Well, under this court and the North Carolina Supreme Court's comparison test, we go to the language of the complaint. And the language of the complaint says very clearly, multiple places, that the injuries for which damages are sought in that underlying action are the injuries to Kayla and Morgan Kushner, the two young women who died, and to Brennan Callan, the driver who suffered very severe injuries. Those are the plaintiffs, the estates of those two young women, and Mr. Callan. The injuries they're seeking or for the injuries they suffered, and clearly those injuries occurred away from the premises, off premises, 2.5 or 3 miles away from the smoke ring smoke shop on Avent Ferry Road. That's what the complaint alleges. You take those allegations, review them, compare them to the clear policy language of the PCOH exclusion, no coverage. And I'd just like to, so obviously, of course, please interrupt me if you have any questions, but just to take you to the allegations of the complaint that make that very, very clear. So starting early on in the recitation of the allegations of the underlying complaint, this is at 247 of the record, paragraph 7 and 8. The plaintiffs, Mr. and Mrs. Kushner as co-administrators of the estates, quote, seek to recover compensatory damages from defendants jointly and severally for Morgan and Kayla's deaths. Those are the injuries that they're seeking to recover for. Next paragraph, plaintiff Brennan D. Callan seeks to recover compensatory damages from defendants jointly and severally for his personal injuries. This is not an action where anyone is seeking to recover damages for an alleged personal injury to Mr. Curtis, who inhaled the nitrous oxide allegedly in the parking lot. Mr. Curtis is not a plaintiff, he's a co-defendant. No one's suing on behalf of Mr. Curtis to recover damages for the inhalation of the nitrous oxide in the parking lot. No, it's the estates of the two young women and Mr. Callan who are seeking to recover damages for their personal injuries. And so it's very clear that those injuries for which damages are sought occurred off premises and are therefore squarely within the PCOH exclusion. Other allegations of the underlying complaint make this equally clear. So for example, there's no doubt, I don't think it's disputed, but in any event, it's right there in the underlying complaint. The allegation is the collision occurred in Plaintiff Callan's lane of travel on Avent Ferry Road. And that's at paragraph 124, 263 of the record. And then paragraph 128 makes clear less than 3 miles from the smoke rings smoke shop. I mean, I think the court could take judicial notice that if you go on MapQuest or whatever, it's a 2.5-ish mile drive from the smoke ring smoke shop's location to Avent Ferry Road where the crash occurred. So these are claims that arise out of the products, Henson's sale of the nitrous oxide cream chargers. The injuries occur away from the premises, and it's as simple as doing that comparison of the two documents, and on that basis, the PCOH exclusion clearly applies.
So with the, well, probably leads to yet another question, but, North Carolina law, I'll go with North Carolina law for a second. As a general principle, the duty to defend is treated as sort of broader, obviously, than the duty to cover. Here you've got that specific language in the policy itself, which says if we have no duty to cover, we have no duty to defend. How does that interplay with the case law on duty to defend? Are we solely bound by the contractual language, or is there still that kind of overlay of the...
No, I'm not here to dispute the general principle that the duty to defend is broader than the duty to indemnify. There's no doubt that's true. I mean, because that principle comes up where, okay, there's an allegation, or at least one of the allegations is that, let's say, one of the bodily injuries for which damages are actually sought occurred on the premises, but there's others that didn't. Let's say, you had a mixed complaint that alleged both. Then the duty to defend would be triggered, but you'd have to see what actually ended up being found in order to figure out, by the jury at trial. That's how you would measure the duty to indemnify. There's no doubt that the duty to defend is broader. I'm not here to dispute that point. What I'm saying is that sometimes, and I've cited a couple of examples, you can do that analysis, look at the pleadings in the underlying complaint, and find that there's clearly no duty to defend against the allegations that have been actually brought. So this would be, maybe another way of answering your question is to say, sure, this would be a different case if Mr. Curtis, who's serving, 16 to 23 years in jail for having killed two of the underlying plaintiffs and severely injured Mr. Callis, if he had brought a claim for personal injuries that he allegedly suffered when he inhaled nitrous oxide in the parking lot, I mean, that would be a much different claim, but you'd analyze the PCOH exclusion's potential application based on the face of that complaint. But that's not what's going on in the amended complaint, in either version of the underlying complaint. So there's just no set of facts that are either in that complaint or going to be subject to proof that are going to turn that underlying action into an action about some alleged injury to the perpetrator, to a co-defendant of the collision. That's not the injuries that are at issue in that case. There's no damages being sought for those injuries. Indeed, Mr. Curtis is a co-defendant who is, they're trying to hold the underlying plaintiffs, are trying to hold jointly and severally liable in the underlying action. Without belaboring it, just a couple more cites to the underlying complaint that I think make this very clear. So it's count 1, alleges negligence and gross negligence against Henson, and that's at pages 264 to 68 of the record. And again, it's just very clear that the bodily injuries that are for which damages are being sought in that action are the injuries to the two Kushner sisters who are deceased and to Brennan Callan, the other plaintiff. And it's right there at paragraph 155. Morgan and Kayla Kushner were killed, and plaintiff Callan was severely injured in the collision as a proximate result of the negligence and gross negligence of defendant Henson Novelties. Again, I understand that Henson Novelties disputes that, but the nature of the action for analyzing the duty to defend is for those alleged injuries. For the injuries to Morgan and Kayla Kushner and to Mr. Callan, the plaintiffs are not seeking to recover in any sense for injuries suffered by Mr. Curtis, allegedly in the parking lot by the inhalation of the product. And so we think this is just a classic application of the comparison test where the pleadings make clear there's no duty to defend. I think it's actually very much analogous to another case we cite in our papers that deals with a materially equivalent PCOH or operations exclusion, and that is the Deason case, Deason versus J. King Harrison, another of this court's cases. There you had the loading of bales of fiber on premises, a similar exclusion that excluded liability for off-premises injuries. Bales of fiber that were allegedly negligently loaded on premises, then driven off premises, I think from somewhere in North Carolina to like Kansas City. When the door opens, the bales of fiber fall out and injure someone. And the court held that's a classic example of where this PCOH exclusion operates, because you have conduct on premises. Here, the sale of nitrous oxide cream chargers. There, the loading of these bales of fiber. Causing injury off premises. There, the fibers fall. Here, the collision that occurs on Avent Ferry Road that injures the underlying plaintiffs and their estates. And there's no coverage. That's just right squarely within the PCOH exclusion. No duty to defend, no duty to indemnify. Another point on the PCOH exclusion I'd just like to address, which is that it's ambiguous. There's no ambiguity as to any aspect of the PCOH exclusion I would submit here. I think that the allegation from the briefs, and as I understood it today, the argument I should say, is that, well, you have the insuring agreement, which provides a general grant of coverage for certain bodily injuries, and then you have an exclusion that takes away coverage for off-site, off-premises injuries. But that doesn't create an ambiguity. I mean, if that were true, then in this court's Hague case, which I know, as I mentioned, a couple members of the panel were also on that panel and may recall. I mean, that's a case where there's a general grant of coverage, but then there's an intentional act exclusion. There's no ambiguity just because you have coverage, grant, and exclusion. You still have to just apply the plain meaning of the exclusion. You can do so at the pleading stage, and I think this court should here. So that's our argument on the PCOH exclusion. As I say, I think it is a sufficient ground. If the court wanted to write, I wouldn't propose to tell the court how to write its opinions, but it's the only issue that the court would have to reach to affirm, and it would not get into the designated premises endorsement, but I do want to address it. I know the court has had some questions about it, and I think there too, it's an independent ground to affirm, and it's a good ground to affirm. It could also be, the court could also affirm on that ground. And just to go through again, to conduct the comparison test that this court's precedents call for, start with the language of the policy. The designated premises endorsement is on 95 of the record. It says that there will be coverage only if the bodily injury or property damage, A, occurs on the premises shown in the schedule, or grounds or structures appurtenant to those premises, or arises out of the projects or operations shown in the schedule. I think A, there's a lot of overlap, obviously, on A between what we've just been talking about. The bodily injury did not occur on the premises or on grounds or structures appurtenant to the premises because the bodily injuries that are at issue in the underlying action are the bodily injuries that occurred on Avent Ferry Road 3 miles away. It's just, and similar to the PCOH exclusion, it's just not the case that the bodily injuries for which damages are sought are an alleged injury that took place in the parking lot when nitrous oxide was inhaled. That's not the nature of that action. It's not a personal injury claim by or on behalf of Mr. Curtis, who supposedly was injured when he intentionally inhaled nitrous oxide under the framing of my colleague on the other side. So that's A. Now, B, arises out of the project or operations shown in the schedule. That does create another issue, and again, that's why it makes this a somewhat more complicated question than the PCOH exclusion, but I also think the comparison test applies and provides a ground to affirm there, and I'll try to explain why. So, the B says arises out of the project or operation shown in the schedule. Now the schedule, if you look at R95, it's blank, but there's a line under it that says, okay, if this is left blank, look at the declarations to determine what operations we're talking about. And the declarations are in a couple of places, but at page 37 of the record and then at page 44 of the record, you have declarations that explain what the operations are. At page 44 of the record, just want to make sure I say it correctly, one of the premises listed is on Hillsborough Street in Raleigh, which was the smoke rings location here. And then it says tobacco product stores. So there's a tobacco product store. There's a premises on Hillsborough Street in Raleigh that's a tobacco product store. Well, the description in that declaration is not the sale of nitrous oxide cream chargers without selling, any vanilla or whipping cream or other items that you would use to make whipping cream. So it's not listed there, and it's certainly not listed there is as alleged in the underlying complaint, an allegedly unlawful sale of the nitrous oxide cream chargers in violation of the Toxic Vapors Act. So it's not part of the operations listed in the declarations. Tobacco product stores. At 37, it says retail smoke shop. It's not part of a smoke shop or tobacco products operation as described in the declarations to be selling nitrous oxide cream chargers with reasonable cause to believe that it will be used for the purpose of intoxication as alleged in the underlying complaint.
That strikes me as that has the potential for a question of fact as to what exactly falls within the scope of a tobacco products.
Sure. Look, I acknowledge, and to be candid, that's why I started off with what I think is a very simple ground to affirm on the PCOH exclusion. But I acknowledge that that is closer to the line of getting into something that would require discovery. But again, I don't think so because, well, let me try to convince Your Honor otherwise by going back to the Hague case that I've mentioned a number of times. In the Hague case, there could have been a question about, all that's alleged in the complaint is that the gun is discharged multiple times and that someone ends up dying. In discovery, it could come out as to whether or not that was an accidental discharge, or I don't know. I mean, probably not. But there's no, you couldn't have known looking on the pleadings what would eventually develop. But it's still appropriate to take the pleadings as they come to the court and determine based on the pleadings whether or not there's a duty to defend, whether there's coverage. So we think it's an appropriate analysis, and just on the face of the policy and the allegations in the underlying complaint, it's an ample ground to affirm. As I say, if the court's not willing to go with me on that or has reservations about getting into that, well, the PCOH exclusion is sufficient unto the day, and it provides a good ground to affirm. Now, I do want to answer any other questions that the court has on the designated premises endorsement, but one other issue I just want to address, because it's in the briefs, is the duty to indemnify, because the court did grant judgment on the duty to defend and the duty to indemnify, and we think that was entirely appropriate. Again, I just will call back, I know I've cited it a number of times, but it's a good case, it's precedent of this court, it's recent, and a couple members of the panel were on it, and that's North Carolina Farm Bureau Insurance versus Hague. Again, the court did that analysis, did the comparison test, affirmed judgment on the pleadings as to the duty to defend, and then it had a brief section of its analysis at the end of the opinion in which it said, an insurer's duty to indemnify is narrower than its duty to defend. It follows that if an insurer has no duty to defend, it has no duty to indemnify. So if the allegations in the complaint show no duty to defend, no duty to indemnify, one follows another. See this court's recent decision in North Carolina Farm Bureau Insurance Company versus Hague. We'd ask the court to both adopt the analysis of the court below on both the designated premises endorsement and the PCOH exclusion, or either, as it deems appropriate, since they're both independent grounds to affirm. On that basis, to hold that there was no duty to indemnify, and affirm that basis of the judgment below as well. And unless the court does have further questions, I will rest on the papers. Thank you very much.
Thank you. Great. We'll hear a rebuttal.
Thank you, Your Honors. Counsel's reference to the comparison test proves exactly my point that I made in my opening argument. It is exactly the reversible error that we allege occurred in this case. The comparison is you take the words of the policy and you compare them to the facts of the complaint. Here, there were no facts. There were only allegations in a complaint. And we need go no further than why this is so important than the Supreme Court in the waste management case tells us. And we actually also, this is at page 13 of our brief, and we also, it's also referenced in a separate case, the North Carolina Farm Bureau case versus Cox. But in the waste management case, the Supreme Court talks about the necessity of looking at all extrinsic facts to the complaint. And it reviewed the pleadings in the opinion and concluded that they did not allege facts covered by the policy. That is at 692, at page 692 of that opinion. But then, in the very next paragraph, still searching for facts to support coverage, the court turned to a deposition. The Supreme Court of North Carolina indicated that in order to find facts to trigger the duty to defend, even when such facts are not in the complaint, even when the pleading itself, as we have in this case, does not trigger coverage, and we don't agree with the judge's determination, by the way, that the complaint does not trigger coverage, but that is what he found. Nevertheless, even when you're in that situation, the court makes it clear that you turn to depositions, and facts outside the pleadings may give rise to a duty to defend. So that's, in my opinion, counsel's repeated reference to the comparison test simply exactly proves our point, that comparison test was not followed in this case because the court and the finder of fact, many times in these coverage cases when you go to trial, there is a separate finder of fact as to the actual facts.
Are we, in analyzing this though, are we not bound by sort of the theory of the case that's alleged in the complaint and the damages that are sought, the alleged damages sought?
Well, I mean, structurally, if it's a, excuse me, battery case, for example, then since insurance policies require accidents, then you would not typically, you would be bound by the structure of the pleadings. But that's not what's going on here. Here we have negligence being alleged. Here we have a whole myriad of negligent conduct that's being alleged that occurred on the premises and pertinent to the premises. And so that's not the issue. And that was, of course, the issue in the Hague case. And while it's true, for example, if there's a criminal conviction and then there's a civil suit thereafter, the court could conclude on a motion for judgment on the pleadings. A criminal conviction is you take judicial notice of that. And that was essentially what the court did in the Hague case. And you have a situation where there's a handgun being fired. That is an intentional act, I mean, unless you're stung by a bee or something and you accidentally, or you discharge it. And in fact, that's one of the most famous Supreme Court opinions in California is the Partridge versus State Farm case, where there was a shotgun that had a trigger that was filed down, and they were in a car, and the shotgun accidentally discharged. And the court went into a whole metaphysical analysis of that. That's not what you had in Hague. You did not have an accident. You had an intentional act that, again, clearly was covered and not covered by the policy. But here we have not only a myriad of allegations in a complaint regarding covered claims that occurred on the premises and therefore trigger the insuring clause pursuant to the designated premises endorsement. But again, we fundamentally disagree that the exclusion applies, and for all the reasons that we indicated. Likewise, the Deason case, we believe it's a different exclusion, it's a different set of facts, and it is distinguishable from this situation. But at the end of the day, Your Honors, I'm sensing that from counsel's, not going to put words in their mouth, but the only issue that we have here from our perspective is whether or not this exclusion does apply. We do not believe that it does. For the procedural reasons we indicate, the exclusions are construed strictly against the drafter. We believe that there is a conflict between the endorsement, the designated premises endorsement, and this exclusion as to when you have conduct, when you have coverage for conduct and damages arising out of the insured's conduct. The carrier is giving with one hand, and what is it taking away with the other hand? That is an ambiguity. At a minimum, we have a right to conduct discovery into that, underwriting of that exclusion, into the application of that exclusion, whether or not that exclusion actually applies. Are there admissions in the claim file or underwriting file regarding this product? I mean, this is a very narrow line of business, a relatively unusual line of business, these smoke shops. And the insurance companies that undertake this type of risk and this type of policy have very specialized underwriting standards, we have a right to see what those are, to see what it is that they believe that these words mean and what these words cover. Likewise, the exclusion carries a very heavy burden of proof, as I indicated, and I don't want to repeat myself, but that does require evidence, that does require admissible facts, testimony, an actual motion for summary judgment, and or a trial. And the actions of the trial court took that away from us. So with that, unless the court has any questions, I'm finished for today. Thank you.
Thank you. Appreciate the arguments of both counsel. Safe travels home, and case is submitted. Thank you. We'll, I guess, adjourn or recess briefly so you can reset, and then we'll come back in ceremonial session.
All rise. The session of the North Carolina Court of Appeals is adjourned.